Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled The Far from Halcyon Isle Maritime Liens, Renvoi and Conflict of Law. So this is the fourth part of the video. The subsequent cases, the majority reasoning of the Halcyon Isle was roundly criticized and followed by Munich GP in the South African case relied on by ALRC 33 at 123, Shorten Steamship Agency in VMV College Sky, concluded the law of England in 1891 wasn't minority had identified in the result of the Colorado. After South Africa amended its admiralty legislation in 1983 to adopt English law as the date as the governing law for the jurisdiction, the Supreme Court of South Africa followed the Halcyon Isle in the Andrico Unity. Corpo GA analyzed the authorities on the correct basis that decisions of the Privy Council was not a binding precedent on the questions of English law because it did not bind English courts or the Supreme Court of South Africa, although it had persuasive force. Ultimately, he concluded the majority in the Halcyon Isle was correct. Corpo GA held that the status of a maritime lien was conferred by operations of law and not, for example, as a matter of contract. He reasoned that the ascertainment of the order of priorities could be or may risk complexity if the forum had to grapple with the order of recognitions of a number of maritime claims from different foreign legal systems with differing legal characteristics. He observed that the right created by a maritime lien was closely connected with the questions of priorities. Accordingly, he found persuasive Lord Diplock's invocations of simplicity in the use of the forum's classification and priority rules. Corpo GA considered that the determinations of whether a particular maritime lien should have a priority ranking tended to merge the role of the law to the forum into have substantive consequences that support using the lex fori for the purposes of both classification and priority. But he also reasoned that in claims for a maritime lien based on collision damage, the double actionability rule in respect of foreign torts applied. In example, the principle established in Philippine v. Aire, of course, since Regi National des Usines Renault S.A. v. Zhang, that is not the law in Australia because it now recognizes the lex loci delicti as the governing substantive law for tort claims. New Zealand courts, being bound by decisions of the Privy Council, have followed the Halcyon Isle for near with the ship's Margarets. In more lines, Shepard G. followed the majority in the Halcyon Isle. His Honor noted that it had been followed in the New Zealand and South African cases above, and also he appears to have said in Canada in Marlex Petroleum in v. the ship's Hyrai. A decision for the Federal Court of Appeal. However, it may be that this honor inadvertently omitted the word "not before followed" when referring to the more recent Canadian case because the court had followed the earlier Supreme Court decisions, as it was bound to do. Shepard G. noted criticism of the majority reasoning but preferred it. Is the time ripe for reconsiderations of the Halcyon Isle in Australia? One answer questions that arises from the majority decisions is the status that any judicial sale would have where the law of the forum had rejected recognitions of a foreign maritime lien. Halcyon Isle appears to have been scrapped soon after she was sold. But what if she had returned to the United States? Could she have been arrested by the necessary men in exercise of their maritime lien there? If the maritime lien is substantive, at least in the eye of its lex loci or lex cause, does it continue to exist despite a judicial sale by a forum that refused to recognize it? Moreover, why is a ship's mortgage entered into in a foreign jurisdictions that after all involves a contract to give security given a status in the law of a forum applying the majority decision greater than that of a right to maritime lien conferred by operations of law in the same jurisdiction in which the mortgage was given. Asgir B.J. remarked of the rules of international law in Zhang. Diane Poser described that subject as a dismal swarm. Professor Chesser praised it as the topic, offering the phrase scope to the mere jurist, even if he or she could seldom rest content with the solution provided. For Cardozo J., it was one of the most baffling subjects of legal science. Lord Diplock said that a complicated kind of partial renvoi would be needed to give effect in the forum to the law of the contract on the law of the cause of actions or late cause. The discussions above has demonstrated that the treatment of foreign maritime lien in Australia law will be influenced by this forum's conflict of laws rules. Those rules have changed in fundamental respect since the decisions in the Halcyon Isle and more lines in respect of foreign torts and possibly the overall way in which Australian law now accommodates the effect of foreign law on the substantive right of parties to litigation hereabout even they occur in another country. The starting point for Australian law would now appear to be Great Gleason C.G. Caudron, McHugh, Common and Heine G.G. said in Praver, namely, two guiding principles should be seen as lying behind the need to distinguish between substantive and procedural issues. First, litigation who resort to a court to obtain relief must take the court as they find it. A plaintiff cannot ask that a tribunal which does not exist in the forum but does in the place where a wrong was committed should be established to deal in the forum with the claim that the plaintiff makes. Similarly, the plaintiff cannot ask that the court of the forum adopt procedures or give remedies of a kind which their constituting status do not contemplate any more than the plaintiff can ask that the court apply any adjectival law other than the laws of the forum. Secondly, matters that affect the existence, extent or enforceability of the right or duties of the parties to an actions are matters that on their face appear to be concerned with issue of substance, not with the issue of procedure. Or to adopt the formulation put forward by Mason C.G. in M. McCain, rules which are directed to governing regulating the mode of conduct of count proceedings are procedural and all the other provisions or rules are be classified as substantive. This principle may be require further elucidations in subsequent decision, but it should be noted that giving effect to them has significant consequences for the kind of case in which the distinction between the substance and procedure has previously been applied. First, the application of any limitation period, whether bearing the remedy of extinguish the right. So, The time is up and the article will be continued to read on the next video. So bye bye and don't forget to like, comment and subscribe. Bye!